All right. Calling matter number 20, Sushant Gupta versus Lee and DeSalvo.
Excuse me, Judge. Can I ask a question, please?
Who is that?
Good morning, Your Honor.
This is Derek Outley. I've been on hold since 9 a.m. this morning, but 10:30 case, they called my name and I haven't heard anything since.
I'm still on the court's 10 o'clock calendar. We're running behind today. We had a number of motions. You're on for 10:30?
Yes.
Okay. We're still on the court's
They
10
called my name earlier and for some reason it just went on to the next case. They didn't.
What's your name?
My name is Derek Outley.
You're on the 10:30 calendar?
Yes, for Brown Design and Tristan Carey.
Okay, we haven't gotten to the 10:30 calendar. You probably entered an appearance and said you were on, but we have not called the cases from the 10:30 calendar.
Okay.
We're still on the 10 o'clock. Matter number 20, Sushant Gupta versus Lee and DeSalvo.
Good morning, Your Honor. This is Sushant Gupta here, the plaintiff. How are you?
Good morning. How are you, Mr. Gupta?
I'm not well. I read your tentative ruling, so I have to say a few things.
Okay.
Yeah, so, Your Honor, respectfully, the tentative ruling appears to address a motion, which I did not bring today. Today's motion is to set aside the sanctions order, which was issued by you on December 5th, not a motion to remove me from the vexatious litigant list. That is set for another date, May 7, 2025. And today I'm asking you to vacate the $23,816 sanctions order that was issued after dismissal without jurisdiction and without proper notice. The court's own records, I went to Jeff Lip, he is the supervisor of the civil department, and he gave me the returned notice of hearing. So that order is void or voidable under 473D, which is void, and 473B, which is surprise lack of notice. And I asked the court to please address the motion actually before it today. You also cite that there is a Department 1 policy saying only the judge who declared me vexatious litigant can remove me from the list. But today, the hearing is for the sanctions. It's not for removing me for the vexatious litigant, And I'm asking you to vacate the original ruling of sanctions based on 473B, 473D, and 1008, which the judge can and should rule because it's your own sanctions order. And after the sanctions, a lot of things have changed. There was a lack of proper notice, violation of safe harbor under 128.5F provision, fraudulent and abusive litigation conduct by opposing counsel, Mr. Brainard, excusable neglect and denial of due process, new facts including a contempt filing order against counsel, Mr. Brainard. Okay.
Objection.
No safe harbor provision was provided. Improper service of notice. I was never properly served the motion or the court notice. Court's own notice was returned, undelivered. I withdrew from electronic service, but Mr. Brainard continued to send me the notices by email. Mr. Brainard has filed restraining order against me with fake and missing case numbers, filed liens and writs without proper notice, used my personal information like my social security number, my home address, my mortgage company address, my mortgage company name, my first lien, and send them letters, has sent me a fake notice of sale which is filed with this court, okay, with a fake sheriff office address, a fabricated sale date, and reference non-existing enforcement documents. And this document falsely claimed that my property would be sold by Orange County Sheriff, but listed the address as the Orange County Men's Jail in Santa Ana. The supposed sale date, June 30th, 2025, was entirely fabricated and does not appear in any valid court or sheriff court's orders. And I would like to address, he was found in contempt of court yesterday because he served me a restraining order by email, a request for restraining order by email with no case number initially. Then when I asked him for the case number, he sent me a fabricated case number. I had to research the own case number myself. And then in the email, he mentioned that because I use True Filing and One Legal, I'm obligated to accept the restraining order by email, which the judge, Kimberly Rebecca, objected, and she put him in the contempt of 4.1 under the rule 4.1.
All right.
So,
I've heard what I can hear at this point. I'm mindful of the time and the fact that the court has not addressed your motion. So I'm going to have to continue the hearing. Mr. Gupta, I'll tell you why this is happening. Your filings are very voluminous and they are very confusing. Your motion that I look at now is noticing the hearing for April 22nd, 2025. The mistakes are being caused by your failure to comply with the rules of court to properly notice hearings. Your notice says it's happening on April 22nd. The court is having to guess and dig through dozens and dozens of filings that are not authorized by the court. All of your filings have to be tied to a noticed motion and have to comply. You can't just file a document. The court doesn't have a hearing every time you file a document. So for your failures to comply with the rules and properly notice today's motion, the court looked at the wrong document. There's so many motions in this case. The court is going to continue today's hearing so that I can actually address the issue of the sanctions order. And and if you have a motion or request, I think there's something else coming up regarding the vexatious litigant order and the order regarding your pre-filing. Make sure it's noticed for the right date and make sure that it's in the right place, because this court can't address the issue of you being declared a vexatious litigant, but I will address the issue of the motion to set aside or vacate the sanctions order that I issued, because the court obviously did not look at that issue. It's been very confusing. So let me give you a new date.
I'm so sorry, Your Honor. I really apologize for that. Do you want any particular page limit I should adhere to? There's
already a motion. I've looked at it, but it was just noticed for the wrong date. It looks like, I just want to be clear for the record, April 22nd, 2025, there's a motion that was noticed for that date.
I'm so sorry, Your Honor, but in all my motions, I wrote April 24th, but there must be some kind of miscommunication. I really apologize from my end. I don't want to overwhelm the court or you with the over documentation. If you give me a particular page limit, I can limit my motion to that page limit, citing all the
your motion
California
court. Your motion's already filed. I'm just going to look at it now. I looked at the wrong one because there's so many. So I'm going to look at the motion you already filed on April 1st, 2025. Shows it was filed at 12 o'clock a.m. So you don't get any additional briefing. That's your briefing. That's the motion I'm going to rule on. Mr. Brainard already filed an opposition to that, I believe. Right, Mr. Brainard?
Yes, Your Honor, on April 8th.
Okay. So the court is going to be looking at the filings already on the docket with regard to that motion. The court apologizes for not having addressed the correct motion. There are just so many in this case. I'm going to ask you, Mr. Gupta, to again, this is the third or fourth time I've admonished you to make sure that you're complying with all of the rules of procedure. Being pro per does not excuse you from complying with the rules of procedure. Let me give you
Definitely, Your Honor.
Let me give you a new date.
I will adhere to the rules, yes. But I just filed the ex parte. Excuse me, Your Honor, I'm actually cutting you short.
I
The
can't
only reason I
address,
filed
I'm sorry, I can't address ex parties. I have to give you a new date. Ex parte, there's
no.
there's matters who followed the rules and they are
Mhm.
getting their next on calendar. I can't address anything else other than give you a date.
May 12th, Your Honor.
Okay.
May
Because
12th.
I'm selling my house, so I just need to do something, that's why I waited already, for so many days. And then because of this reason, I'm not able to sell my house because Mr. Brainard has filed
Okay,
2
understood,
liens.
Mr. Gupta. I'm sorry, but I have several other matters. You've heard another person's been
Okay,
waiting. They've been following the rules of procedure,
I
giving
understand.
notice. I
I understand.
have to address them first. So
I understand, Your
I'll
Honor.
address your ex party at 1:30 if there is a basis to address it, but everyone else is still waiting for me to address their matters, okay?
So should I come back at 1:30 then?
There's no hearing on ex parties. I'll address your ex party at 1:30. I don't have hearings. I just look at the papers, okay?
No, I haven't filed any ex parte for today.
Okay, then there's nothing else that I need to address with you today. Okay.
So what regarding the sanctions?
Again, I'm addressing your motion at the new
Oh,
hearing
okay.
date. Okay?
Okay. So what is the new hearing date?
What's the new hearing date? We got 30 days.
Not May 12th, Your Honor. No, more time.
Sorry?
May 12th.
May 12th. We'll do it at 1:30 because your matters often take a lot of time. So May 12th at 1:30 is the new hearing time
And
on.
as I asked you, I can limit it to as many papers as you want.
No more
I will
filings,
not
Mr.
overwhelm.
Gupta. Mr. Gupta,
Okay.
no more filings. I already told you there's
Your
a
Honor.
motion on file. Go ahead, Mr. Brainard.
Yes, ma'am. On May 12th, we actually will be in another department with Mr. Gupta seeking a civil harassment restraining order. And I think that's a conflict.
That's on May 19th.
Oh,
That's
no,
on
I
May
think
19th.
that motion was advanced and granted. It was, that's right. I
It
withdraw
was
that.
not granted.
One at a time.
You were found in contempt.
Mr. Gupta,
Okay.
I'm hearing
Sorry,
from one
sorry.
person at a time. Mr.
Okay,
Brainard
sorry.
was patient
I
and waited
apologize.
for you to finish.
Okay.
Go ahead, Mr. Brainard.
Yes, on May 12th, we had a motion pending to serve Mr. Gupta by electronic service, alternate means electronic service. The court advanced that yesterday and granted it. But so I withdraw that. It's my mistake. I'm sorry to waste your time. May 12th is fine.
May 12th at 1:30. Can you both make it then for a hearing on this
Yes,
motion? Okay. All right.
But Your Honor, I have to sell my house. May 12th. I already waited for so long.
I'm sorry, Mr. Gupta. You have to comply with the rules of court. The court cannot issue this court does not have jurisdiction to give you the relief that you're seeking. This is a limited jurisdiction courtroom. Okay.
But you were the one who sanctioned. You were the one who put the sanctions on me.
I'm gonna have to cut you off and hang up on you, Mr. Gupta, because you're not following the rules of court. You're out of order, continuing to speak after the court has ruled that the matter is concluded.
So should I do like a writ of mandate then for this?
All right. Now we have.
See,
I'm
look
calling
at
the
this
next
fraudster.
matter. I am.
Mr. Fraudster Brainard.
I'm going to log off, Your Honor,
right.
respectfully. Thank you so
Thank
much.
you.
Have a nice-
Thank you both.
Wow, look at him.
Can you please log him off?
Yes, Your Honor.
All right.
Your Honor, this is not fair.
We have to take a break for the 10:30 folks to let me know who has submitted or checked in. I apologize to the folks who have been waiting for their matters to be called. I will do my best to address that. I do see there's a matter on from 11 o'clock. We'll try to get started before we have to take a 12 o'clock recess, but we'll see what we can get through. We'll try to move quickly.